President, please be seated. The court is now back in session. Before we hand over to the prosecution to make their closing statement, today's hearing will be a bit long and we may be late. We already communicated with the transportation unit to ensure that the buses schedule could be extended to, for example, 20 to 30 minutes late so that staff from the court can be accommodated home. We would like now to hand over to the parties to the proceeding to make a closing statement concerning the fitness to stand trial of Mrs. Ieng Thirith. The co-prosecution will have 30 minutes for this. You may now proceed.
Thank you, Mr. President, and good afternoon, Your Honours. If I may begin by indicating our positions on each of the three questions that Her Honour Judge Cartwright has asked us to address, and then perhaps move on to more detailed submissions as to the way forward. As to the first question, whether the undisturbed decision as to unfitness to stand trial ought to be revisited in any way, our response to that is no. We are of the view that the evidence before Your Honours has confirmed that Ieng Thirith suffers from moderate to severe dementia, that her cognitive abilities are affected to a degree such that she is not currently able to exercise her fair trial rights, and she's therefore currently unfit to stand trial. As to the second question, whether any request is to be made as to continued detention, the answer is also no. The co-prosecutors consider that we've reached a stage, having exhausted the immediately available measures to improve Ieng Thirith's cognitive functioning, where immediate recovery or recovery within a reasonable period of time is highly unlikely. It is therefore unlikely that she will face a trial again in any immediate or foreseeable period of time, and therefore the grounds for her continued detention in our respectful submissions no longer exist. As to the third question, as to whether any conditions are being proposed by the co-prosecutors, our position is that a range of conditions should be imposed, a range of conditions that are reasonably necessary and proportionate, and we will deal with them in turn. But before I move on to them, if I can try and address briefly also Your Honour's question as to the legal basis for the imposition of any conditions. We're happy to provide further written submissions if Your Honours consider that necessary, but I will try and summarise our legal position at this point and hope that is of some assistance. We start from the premise that at the international law, the finding of unfitness of an accused cannot lead to the termination of proceedings. A termination is not a consequence that follows from a finding of unfitness. We've made submissions on this at prior hearings, so I'll be very brief on this point. From the statute and rules of the ICC to the available international jurisprudence, and of course the law and internal rules of the ECCC, there is no legal basis for a termination of proceedings in the event of unfitness. The default position seems to be, if one can search for a common ground between the various jurisdictions, is that proceedings are stayed, an indictment is not withdrawn, the case is not terminated, but consideration is given to what, if any, measures are appropriate. On this, I would note briefly that the Supreme Court chamber appears to have arrived at the same conclusion, and that is found at paragraph 19 of their decision of the 13th of December 2011. Incidentally, the chamber also considered whether during a stay of proceedings measures of compulsion can be ordered against an accused, and I think that goes to the question Your Honours have asked, and they go through a number of decisions at the international level which indicate that indeed measures of compulsion, if necessary and appropriate and proportionate, can be imposed. I'll quote briefly from paragraph 25 of the Supreme Court Chamber's decision, more for the benefit of the public, because I know Your Honours are familiar with this jurisprudence. Neither unfitness nor other serious obstacles to proceedings remove from the court's realm the application of measures, including continued detention, aimed at securing the presence of the accused at trial. Skipping one sentence, moreover, unconditional release seems only to be exceptionally applied on humanitarian grounds in cases of a par excellence terminal condition. And I will slow down for the interpreters. I note I am a repeat offender. One may then look at how international courts have dealt with situations comparable to this one. In the case of Nahak, which of course we've looked at previously, as Your Honours are aware, the court arrived at a finding similar to that which we propose is appropriate in this case, that an accused was unfit to stand trial. The court suspended the proceedings. Relevantly, in our submission, it did not relate that decision to any ongoing treatment or any foreseeable event that would lead to a resumption of the trial. But the court nevertheless noted that a resumption may well be possible, even if remote. And the court ordered a number of restrictive measures. Those measures are not set out in the decision itself. They're detailed in a separate earlier decision, and I'll give the date of that document for the record. It's dated the 17th of March 2004. It is available on the internet. We're happy to provide a copy if parties or the judges are unable to locate this decision. Other cases of relevance. In the case of Kovacevic at the ICTY, again, there was a finding of unfitness to stand trial due to mental illness, and an order was made for a series of restrictive measures. I should say it was an order for provisional release, of course, subject to a range of restrictive measures, including measures to protect the integrity of the proceedings, to protect the evidence, and essentially to ensure that the accused does not abscond. Two more cases are relevant. Again, ICTY decisions, Talic and Djukic. We've, I think, touched on these in the past, so I will not spend any great amount of time on them. In Djukic, the accused was terminally ill, suffering from cancer. It was, in fact, the prosecution that had applied to withdraw the indictment against General Djukic. And the trial chamber in that case refused that request. And in addition to refusing that request and noting that a withdrawal of indictment, effectively a termination of the proceedings, is not permitted at the international level, the court went on to impose a number of restrictive measures on the accused. The case was ultimately terminated by the appeals chamber on the 29th of May 1996, following the accused's death. And this would be one of the cases that, in our submission, reflect the approach taken by the Supreme Court chamber to this issue. And lastly, Talic, another terminally ill accused. This decision was rendered on the 20th of September 2002. At page 5, this is in a section entitled Application of the Law to the Facts. The chamber noted that there can be no doubt that Talic is suffering from an incurable and inoperable locally advanced carcinoma, which presently is estimated to be at stage 3B, with a rather unfavourable prognosis of survival, even on short term. In this case, of course, Your Honours, the accused also passed away, but in provisionally releasing him, the ICTY trial chamber again imposed a range of restrictive measures, in fact, quite an extensive range of restrictive measures. Coming back to the issue of appropriateness and the legal basis for an application of restrictive measures, perhaps it may be useful if I refer first to the provisions of the internal rules, which in our submission give Your Honours the power to order such measures. We submit that that power is contained in Rule 82, Sub-Rule 2, which provides that Your Honours may at any time during the proceedings order the release of an accused, or when necessary, release on bail or detain an accused in accordance with these internal rules. And we would submit that by analogy you would then turn to Rule 65, which deals with bail orders that can be issued by the co-investigating judges. And that provision in Sub-Rule 1, of course, provides that the court may order release from detention on bail. It shall specify whether a bail bond is payable, and significantly, it may impose such conditions as are necessary to, 1, ensure the presence of the person during the proceedings, and 2, the protection of others. And that brings me back to the issue of necessity and appropriateness of measures. In a nutshell, we say, Your Honours, that for as long as the case before you is not terminated, even though the trial is suspended, there is always at least a theoretical possibility of a resumption of the trial. It is a theoretical and remote possibility, but it is one that we submit you can take into account. To give a simple and perhaps blunt example, we don't know currently of any cure to the disease that Ieng Thirith suffers from, but we equally don't know that a cure may well be found. The essential reasons that we say you should continue to impose a limited set of conditions perhaps is threefold. These conditions would be necessary to ensure that the accused does not abscond, to ensure that she doesn't interfere with the proceedings which are in progress, with the trial that is afoot, to ensure that the integrity of the proceedings as a whole is protected, and that Your Honours continue to exercise judicial supervision over an individual who continues to be subject to an indictment. Now, I want to pause here and also stress that we're very much aware of the fact that a restriction of one's right to liberty is an exception. It is a restriction that should not be ordered lightly. It, of course, cannot be indefinite. It must be reasonable, and it must be proportionate to the aims sought to be achieved. I will set out the 6 conditions that we say would be appropriate. Number 1, Ieng Thirith should be ordered to reside at a specified home address to be provided by her counsel to the court. Secondly, she should make herself available for a weekly safety check by the authorities or officials to be appointed by Your Honours. Number 3, she should be required to surrender her passport and her identity card. Number 4, she should be directed not to contact directly or indirectly the other co-accused, excluding her husband, Ieng Thirith. Number 5, she should be ordered not to contact directly or indirectly any witness, expert or victim who is proposed to be heard by the court, and also directed not to interfere in any way with the administration of justice before this court. Lastly, she should be ordered to undergo a medical examination by medical practitioners to be appointed by the court on a regular basis, which we say would be every 6 months. The first such examination to be undertaken in March 2013. That last condition would ensure that you're able to monitor the progress, deterioration or otherwise of Ieng Thirith's medical condition, and also it would ensure that Ieng Thirith is not facing an indefinite period of restriction of her right to liberty. Let me assure Your Honours, we've taken great care and considered very carefully these conditions. And I should say we started with a significantly longer list. We put forward this list of conditions which we submit are reasonable and not onerous. And we respectfully ask Your Honours to impose them. One practical matter which arises is the enforcement of these rules by the court. If we accept that Ieng Thirith suffers from a significant impairment of her memory, and that her cognitive abilities are reduced, then we must also accept that there will be a degree of difficulty on her part in complying with these conditions without some assistance. While the modality of enforcement of these measures is obviously in Your Honour's discretion, one option of dealing with this issue, or one potential solution, is provided by the recently enacted Code of Civil Procedure, which provides in Articles 24 and 28 for the appointment of a guardian or curator who can assist a person who is unable to recognize and understand the legal consequences of their actions. I should correct my reference to the code. It is the Civil Code of Cambodia, not the Code of Procedure. Just returning briefly to the issue of continued imposition of these measures, the ICTY has commented in Talich that provisional release measures must be proportionate. And of course, we know that at the international level, detention cannot continue indefinitely, as I mentioned earlier. And of course, there is an overriding right to a trial without undue delay. And one might ask, looking at that last provision, or the last right, which is enshrined in the ECC law in Article 35 new, how do we ensure that? How do we continue to impose restrictive conditions on an individual who is not facing a trial in the immediate future? We would simply say, Your Honours, that we have not reached a point in time where an undue delay has occurred. Under the jurisprudence of the European Court of Human Rights and in the decisions of the Human Rights Committee and of international courts, there is extensive discussion of this issue. What is reasonable depends on the circumstances of a case. That must take into account the complexity of the case, the diligence with which the court has acted, the overall length of time. As I bring my submissions to a close, we would say that this court has acted diligently. It has progressed this case at each stage with expedition. This, of course, includes this current phase. Your Honours have dealt expeditiously with the matter of fitness to stand trial. Ieng Thirith's rights have been protected at all times. And to the extent that if Your Honours decide to release her from detention, her rights will be restricted less than they have been thus far. We say that we have simply not reached a threshold where one could submit that an undue delay has taken place. Ultimately, Your Honours may revisit the issue, and an appropriate point in time may be at the conclusion of the proceedings in case 002/02. That provides a definite point in time for Ieng Thirith at which she can expect a reconsideration of these conditions. And of course, under the rules, she also has the right to apply for a variation of the conditions or their termination should there be a change in the circumstances. Those are my submissions. I would thank Your Honours for the time allocated to us, and again I would thank you for the diligence and professionalism with which the Chamber has dealt with this issue.
The President, Judge Katrai, you may now proceed.
Yes, thank you, President. I have one or two questions by way of clarification concerning the submissions made on behalf of the co-prosecutors. I am assuming that the 6 conditions you would wish the Chamber to impose are in the category of bail conditions, that is, conditions on release. I would like you to clarify if the procedures in the Cambodian Civil Code were invoked and a guardian appointed, what possible sanctions could there be if the accused did not comply with your conditions?
Well, Your Honours, ultimately, we would argue that a failure to comply with an order of the court can be dealt with under the internal rules. It can be dealt with under Rule 35 as an interference in the administration of justice. Obviously, in some jurisdiction, any breach of a court order amounts to contempt of court. It is difficult for me to speculate in the absence of a specific example, but any range of orders may be available, from warnings to directions to a guardian, ultimately perhaps to a review of the conditions imposed, if that were considered appropriate.
So on that topic still, the sanctions arguably would fall on the guardian rather than the accused, or if they fell on the accused, it might logically lead to her being placed back in detention again, still with a diagnosis of unfitness to stand trial. Is that a fair summary of the prosecutor's position?
Thank you. Thank you, Your Honour. We don't take the view that that outcome necessarily follows. The guardian takes over the legal interests of the accused if the guardian has made all reasonable efforts to comply with Your Honour's orders, and if Ieng Thirith were to independent of the guardian's advice and assistance, breach your orders, then Your Honours could consider what measures are appropriate. We don't think that it would follow necessarily that she may be placed back in detention. You may consider more restrictive measures. We did not propose house arrest. You could consider the measure of house arrest. We've proposed a requirement that she reside at a specific residence, but not necessarily that she be effectively detained in that residence. And if I may add, in any event, I want to stress that we only see those measures continuing for as long as Your Honours consider them reasonable, and up to a point, and certainly before you consider that an undue delay would ensue if a trial were to take place.
So you are suggesting consequences for Ieng Thirith if she fails to abide by the conditions, even though you have conceded that she does not have the mental capacity now to stand trial. So it seems to me to be an absurd outcome, because if she were breaching conditions imposed on her, there can be no inference of a deliberate breach of those conditions, given her medical condition as you have conceded it.
Thank you, Your Honour. Our submission would be that it does not turn on whether or not it's a deliberate breach, and whether or not Your Honours want to exercise punitive measures, but rather what measures would then become necessary to safeguard the integrity of the proceedings. By way of an example, if Ieng Thirith were to contact a witness, attempt to intimidate him or her into not giving evidence, then Your Honours could consider imposing a more restrictive regime, not because she did so deliberately, but perhaps because it is necessary to safeguard the integrity of the proceedings. We do, of course, always have to act within the law. Ultimately, no measure can be inhumane or degrading, but it's hard for me to speculate. I would say that it would depend on the circumstances of each situation if it were to arise. I would add that, of course, the international tribunals have imposed restrictive measures on accused who are suffering from mental impairments, so Your Honours would not be making such an order for the first time.
Can I look at a couple of your specific conditions that you submitted are appropriate? A weekly safety check. Whose safety? Ieng Thirith's or the public's?
It would be a check of both, I would suggest. The ECC rules provide for an order of detention to protect the accused, and by analogy, the conditions on release can follow along similar lines. So we would say you could order them to protect both her and the public, or more specifically, witnesses or victims. Of course, one can recall that Ieng Thirith has exhibited aggressive behaviour on a number of occasions, and we've heard that evidence consistently.
The other condition that you suggested that I'd like clarification on, a regular 6-monthly medical examination. Are you proposing that this be a reprise of the expert opinion, or perhaps that Professor Choktida would continue with her medical checks, the outcome of which may well be that she is found suddenly to be fit to stand trial?
No, Your Honours, we're not suggesting those medical examinations to be performed for the purposes of a reassessment of fitness. If information were to come to light that changes the present circumstances, Your Honours can order such a reassessment. It is the purpose of this requirement is really in the interests of the accused. She has benefited from ongoing medical treatment in the detention facility. It would assist her also, and I think it would assist the court in considering the reasonableness of a continuation of the measures at any point in time.
And 2 final points, and I hope the President will forgive me. One is the undue delay submission that you made. Of course, Ieng Thirith has been in detention for about 4 years now. You seem to favour her release. Do you consider, there's 2 parts to my question, do you consider that any longer term of detention meets the other standards that other internationalised courts have imposed? And secondly, would you agree with the proposal for immediate release with conditions to follow? And I immediately emphasise that this is a question I alone am asking. It has not been discussed amongst my colleagues.
I'm afraid on the second question, Your Honours, equally I'm not authorised to respond. I would have to take instructions from the co-prosecutors. My instructions at the moment is that a release should be conditional, and I take that to mean that conditions should be imposed at the time of the release. And certainly it is our view that these measures can be put in place expeditiously. Coming back to your earlier question, whether a continuation of or imposition of restrictive measures would meet international standards as set by the international tribunals, Your Honours would be familiar with the fact that accused before the ICTY and the ICTR are often held in detention for periods of time well in excess of that for which Ieng Thirith has been detained. I'm sorry that I'm unable to cite cases or provide statistics off the top of my head, but I'm prepared to provide those in due course if you so wish. I can recall certainly cases ranging from 5 to 10 years at the international tribunals. And I would recall that, of course, Ieng Thirith's detention will cease within less than 5 years if she were to be released now. The measures that we're proposing are significantly less restrictive.
Thank you, President, for allowing me that time to seek clarification of the prosecutor's submissions.
The President, thank you. Next, we would like to proceed to co-lead lawyers for the civil parties to make their closing arguments. They may now proceed. Counsel Baek Ang. Thank you, Mr. President, and Your Honors, and everyone in this courtroom and the public, including the civil parties. I am now raising a few points concerning the closing statement, and my colleague, Mrs. Elizabeth Simonoff, will add on top of what I stated. Your Honors, we have already discussed at length concerning the tests that had been administered by the experts and Dr. Chak Tida. We also discussed the regime of the assessments and how Mrs. Ieng Thirith's behavior was assessed. I would like to pinpoint in particular to the approach in putting questions to Mrs. Ieng Thirith. The international standardized tests were used by Mr. Sina Fazel and Professor John Campbell, and they were both of the opinion that such tests would not be allowed to modify. However, Dr. Hood Lina said that the tests could be modified if the doctors had discussed about the modification of the test before it could be administered. The international experts said the test could not be modified. However, one of the doctors said that he tried to modify the test. My question is, how strict the test could have been, or could it be modified or not, if the experts themselves also are not consistent in that. If we talk about Cambodian context and culture, to communicate with people or patients, or to be able for foreign nationals to understand our cultures, they could have been familiar and studied the language at some point and the cultures to establish this kind of understanding before they could properly administer any test on any Cambodian. But the professors or doctors were not fully informed of this, and Mrs. Ieng Thirith used to be highly educated, and she also was involved in leading the radio station during the Khmer Rouge regime. She at times could easily manipulate her responses to fit her needs. For that, the three experts also had to take into account these specifications and they should have modified the questions to suit the circumstance. In the contrary, the experts did not try to modify the test to establish whether Mrs. Ieng Thirith was feigning. With regard to Dr. Chaktida, although she is not as highly educated as the other two professors, Professor Campbell and Fazel, her experience is plausible enough, and that she has been fully familiar with the Cambodian culture and traditions, and she has been treating patients of that kind for several years, and she is the best person who can understand Cambodian patient as she is Cambodian herself. But this was missed in the part of the preparation for the international doctors, experts, and this omission would also impact on the findings of the international experts. And we were talking about the slamming of the door by Mrs. Ieng Thirith using her crutch, her urinary incontinence, and we heard the experts talked in particular about the feeling that somebody could have been hiding in Ieng Thirith's mosquito net. So we could see that language in communicating with the patient at that time plays a significant role in the findings itself, and it has to be assessed properly. And we already experienced this problem when the terms dementia was not properly interpreted and corrected by Professor Hoodlina. So when the communication had to go through interpreting, we can call into question the result of the finding. And even in our penal code, the terms in Khmer could be divided and not in harmony. In other words, the Khmer terms for dementia are not fully agreed across the board, and for that reason, the problem in translating or interpreting the language for communicating with the patient had to be very carefully reassessed. And when the experts came to visit Mrs. Ieng Thirith, they were all male doctors, and the environment was not friendly enough for Mrs. Ieng Thirith to cooperate, and she felt friendly and more comfortable when she was interviewed by Dr. Chaktida. We talked to the civil parties who observed the proceedings, about 40 civil parties who were in agreement with the method applied by Professor Thida, because they were also of the opinion that the tests administered on Mrs. Ieng Thirith by Professor Thida was suitable, and the test was amended to suit the situation in Cambodian context. So we would like to submit that there should be a group of doctors where there would be more women doctors than men to administer tests on Madame Ieng Thirith, because only women doctors who understood Cambodian culture and tradition would be able to establish a good relation with the patient. And finally, we submit that more experts should be appointed to reassess her condition. Mr. President and Your Honors, I now conclude my statement, and I would like to cede the floor to my colleague.
Oui, Mr. President, Your Honors, esteemed colleagues, and all those present in the courtroom, I think you will surmise that the position of the civil parties is rather complicated. In fact, it is always the case in a trial of this nature, given the complexity of the facts. Nevertheless, I shall endeavor to answer the questions that have been put forward by Your Honors. To begin, I believe that you have already heard the comments of Mr. Pik Ong, who has recommended the appointment of new experts. I believe that our answer to that question is abundantly clear. Perhaps there is a reason to examine fitness, and the civil parties would request the appointment of new experts to provide expertise that would then be appreciated by Your Honors. With respect to detention, in the scenario that Mrs. Ieng Thirith be found once again unfit to stand trial, without betraying the position of the civil parties and the rights that are to be enjoyed by the civil parties, I wish to say at the outset that by allowing for civil party participation, the extraordinary chambers have endowed them with rights to be full-fledged parties to this trial. It doesn't come as a surprise to anyone when I state that the civil parties, and I'm talking about the consolidated group and our clients, have a very deep conviction and desire to see this trial come to a conclusion, to have all 4 accused be tried, and to arrive at a guilty verdict, and that this court should do its level best to arrive at such a judgment. Nevertheless, I would indicate that on behalf of the civil parties, and as lead co-lawyer, the civil parties would agree that the rule of a fair trial be applied and that this be enforced with respect to national and international rules. The civil parties cannot heed any decision that does not fully respect all of their rights. The civil parties obviously cannot speak to the medical information that is provided by the experts, but with respect to the second question, it is clear that the civil parties do not wish to see the violation of any of the parties' rights. In response to your third question with respect to additional measures to be implemented should the Chamber declare the release of the accused, we fully subscribe to the position of the co-prosecutors. I can state very clearly that the civil parties who are present here would like to see those measures ordered. With respect to the legal position of the lawyers, I would defer to the Chamber's decision, which shall apply all international criteria. I hope I have sufficiently answered all of the questions posed by the Chamber. I would simply add one final comment to convey the perspective of civil parties. Regardless of the final decision to be rendered by the Chamber, whether detention be maintained or whether a new panel of experts be appointed, or if the accused be released, or if new measures are ordered, regardless of the decision to be rendered, it is very important that Your Honours provide very clear explanations to the civil parties with respect to the findings that you will reach, as well as the basis on which your decisions are founded. I speak on behalf of approximately 4,000 civil parties and on behalf of all victims. It is only if the Chamber is able to fully explain the foundation and basis of its decision that the civil parties will be left with the impression that their rights will have been respected and that they will be in a position to understand this finding of justice to which they have taken part. Those are the comments I sought to convey. The civil parties will defer entirely to the trial chamber and has full confidence in the decision that it will reach. I thank you, Your Honours.
The President, thank you. Next, I hand over to the defense team for Ms. Ieng Thirith. You may proceed with your closing statement. Counsel Pat Persieng. Good afternoon, Mr. President, Your Honours. My name is Pat Persieng. I am the National Defense Counsel for Ms. Ieng Thirith. I would like to now make a final statement concerning her mental status and fitness to stand trial before we close the hearing. After listening to the closing statements by both the prosecution and the civil party lead co-lawyers, I am of the opinion that the requests made by the civil party lead co-lawyers were not acceptable because they are requesting another team of experts to reassess the mental status of Ms. Ieng Thirith once again. But if I understand correctly, these teams of experts was the fourth teams of its kind. The first one was conducted by Dr. Ka Sumbonat and Professor Benedict. And the second times of which was conducted by Professor Campbell. And the third assessment was conducted by Dr. Kaltunli Hutlina and Sina Fazol. And fourth, this assessment, the reassessment, was conducted jointly by Professor Campbell, Dr. Sina Fazol, and Dr. Hutlina. So this was the fourth time already that we conducted assessment on the mental health status of Ms. Ieng Thirith in line with the standards of the World Health Organization. For example, the experts have administered standard tests, including the MMSE test. So this test was administered properly, and I don't think that there is any reason to delay any proceedings any further by appointing another team of experts. Secondly, the civil party lead co-lawyers also mentioned the report by Dr. Chaktida. I do not understand why the civil party lead co-lawyer was making this request, because if you compare the two reports, one being prepared by the experts and practitioners in the field who had both academic qualifications and practical experience for many years, and they also had the report by the physiotherapists from Singapore. It also corroborates with the report of the expert, whereas the report by Dr. Chaktida was not appropriate, and there were a lot of shortcomings. In addition, she prepared a report based on the information from the nurses who reported to her regularly. So if she relied on the reports of the nurses, her report was not good enough. It was not grounded. So if the information was merely taken from the nurses, there was no substantial ground to support the accuracy of her report. And in addition, we asked Dr. Chaksi Nat whether or not she smelled anything bad, the bad odor from her room when she visited Ms. Ieng Thirith there. She said that she did not smell anything, but actually that was completely wrong, because even the women guards who from time to time take Ms. Ieng Thirith to the toilet, they mentioned very clearly that twice or three times a week, they had to have her carpets or have her mattress and other stuff in the room to get them clean. So the situation was deteriorating, and it is getting degenerative. So that situation was obvious, but it was strange when Dr. Chaktida said that she did not smell anything bad in the room of Ms. Ieng Thirith. And the third idea raised by the civil party lead co-lawyers concerning the female doctors who were supposed to attend to the female patient. That is not really the case. I don't find it convincing enough. You know, even when the ladies deliver babies, sometimes they also have the doctors who have the pregnant woman deliver the baby as well. So there is no difference whether or not the physicians are males or female, but what is important is their practice, particularly their experience in relation to the psychiatric expertise. And I think that on that particular point, the expert has already explained very clearly. Now, in response to the statement made by the prosecution, they have raised 6 points in relation to the condition for if any release order was handed down by the chamber. The prosecution requests that the accused Ieng Thirith.
The co-prosecutor actually would like her release on condition, but we feel that she would be under much pressure if she's still under constant watch under this kind of conditional release. So we submit that our client shall be released unconditionally, and that we should allow her family members to take good care of her after this. And we believe that her family members could also help to ensure that her health is not seriously deteriorating after she is being released. I thank you very much indeed, and I conclude my statement. I would like to cede the floor to my colleague.
May it please you, Mr. President, Your Honours. As you appreciate from what has been said on behalf of Ieng Thirith, our answers to the 3 questions in essence are: firstly, there should be confirmation of the decision reached last year, not contested by the prosecutors, that Ieng Thirith is unfit. In the light of the evidence given in this hearing, she is unfit to plead at this stage and also unfit to stand trial. In answer to the second question, her detention should therefore cease and she should be released from the detention facility without any conditions remaining. We submit that there is no longer any legal basis for her detention or release subject to conditions. If I could just briefly develop each of those 3 points. The co-investigating judges put in motion the inquiry and examination of the mental health of Ieng Thirith. That proceeded on the basis of information they had from the detention centre as to the nature of her behaviour, which was changing. As a result of that decision by the co-investigating judges, she was deemed to be suffering from a mild cognitive impairment after an examination by Professor Carr, Cambodian, and the international Dr. Brinded. And that was in November 2009. By 2011, there had been an apparent deterioration in her behaviour and cognitive functioning. The defence in February 2011 expressed their concern and requested that she should be examined as to her fitness to stand trial. 3 days after, Professor Chuck Tida was brought in as her doctor. And the court is very familiar with what has happened thereafter. Professor Campbell, who is extremely experienced, and we examined the extent of his knowledge, expertise, and reputation worldwide on the last occasion when we looked into the question of Ieng Thirith's mental state. He found her last year to be suffering, as he believed, from Alzheimer's disease. The trial chamber, encouraged by all parties, brought in a number of other experts, all considered to have sufficient knowledge, some greater than others, to make the necessary assessment. The conclusion last year was that she was unfit to stand trial, and that was unchallenged by the prosecutor in any meaningful way. As a result of the decision of the higher court, there has been a significant and impressive input into her medical treatment to see whether it is possible to render her in a better cognitive state. And that has failed in spite of a lengthy period on appropriate medication and in spite of quite intensive therapy from trained nurses. People from Cambodia who have formed good relationships with her. She, sadly, is one of the 2/3 who do not respond to any form of treatment. As a result, further assessments at the beginning of this year and now this week have caused the doctors to conclude that she suffers from moderate to severe dementia, that she is cognitively impaired to the extent that she cannot exercise her fair trial rights, she cannot meaningfully participate in her own trial, and the doctors, all now very familiar with the Strugar standard and the capacities, have found she is unable to meaningfully participate in any aspect of her trial, and therefore can't exercise her fair trial rights, and therefore clearly cannot participate in a trial which is to be viewed as a fair trial. The nature of her condition is such that she cannot respond to treatment and she cannot improve with or without treatment. And that, as we heard this afternoon, is because her brain cells, which are used in her cognitive functioning, are no longer there. They have died, and as the doctors informed you on the last occasion, they cannot be regenerated, as is the case with some bodily cells. As a result, it matters not how long anyone waits, Ieng Thirith will simply deteriorate further. She will never get better, and she will not remain stable. No doubt, in years to come, there will be medication or other methods of stem cell research which make the situation different. But we all know that any drug has to be tested at length over years, and therefore the speculation that something might happen in her lifetime is no more than that, is unfounded in any available material. There is nothing that has been put before you, Mr. President, and Your Honours to indicate that at any time in the near future we are likely to have any medication or form of treatment that is going to alter the current situation. And therefore, we submit that to do justice to the evidence in this case, the time has come to confirm that she is not in a position to be tried and will never be so. And hence, the decision previously made should be confirmed. The evidence not only confirms it, but indeed makes it even more clear that that was the right decision that was taken last year. To move on to develop the second point, it links, of course, in with the first. Once it is apparent that it is not possible, due to the mental state of Ieng Thirith, for her to participate in a trial now or in the future, there can be no justification for her further detention. To remind the trial chamber of Article 5 of the ECHR, which guarantees the right to liberty of all persons. The Supreme Court has recognized the significance of that right and has concluded that the international rules of this court and the provisions of the Cambodian Code of Procedure must be read in the light of that right to liberty. That right to liberty is a fundamental right. It is closely linked to the presumption of innocence, which, of course, is one of the guaranteed rights under ECC law and set out at Rule 21 of the internal rules. And therefore, if there is a presumption of innocence and a right to liberty, that right is only replaced by detention in circumstances which justify it. And that is why, under Rule 63 of the internal rules, is set out the factors to be considered and the manner in which provisional detention should be exercised. And the provisions of Rule 68 allow for provisional detention to continue once the closing order has been made and any appeal period has expired. But fundamental to these provisions is the need to ensure that the attendance of the charged person who becomes the suspect, the accused, is ensured for the trial process. Any person who can be trusted to be at liberty remains at liberty, albeit sometimes subject to conditions. Ieng Thirith was not granted her liberty subject to conditions back in November 2007 because the co-investigating judges and confirmed by the pre-trial chamber took the view that she was at risk of non-attendance if granted freedom, that there might be interference with witnesses, which was a risk, particularly once details of the case file became apparent, and that there might be some public disorder were she not to be detained. But the thrust of the provisions is to ensure that the individual concerned is present at the trial when it takes place. And therefore, if, as the reality must be, there is to be no trial, then clearly any detention would be entirely without foundation and unlawful. Of course, question 3 follows on from that, because to impose conditions on any individual presupposes that they are, without those conditions, going to fail to attend their trial. That is the purpose for which a trial chamber, if it considers provisional release to be appropriate, will impose conditions. They all have in mind preserving the integrity of the evidence, ensuring there's no interference with witnesses, which might otherwise work to the advantage of the person who is to stand trial, and most significantly guaranteeing the attendance of that individual. And therefore, for the prosecutor to propose that there are 6 conditions makes no factual sense in the circumstances and is without any legal authority that we can find. It is particularly difficult to comprehend the application for conditions of this nature against a background where the prosecutors have accepted that she is unfit to stand trial and accepts that she should not be held in detention. We have looked for any authorities which can assist the trial chamber in this respect, and perhaps a case of relevance and significance that we would cite is that of Bridjanin and Talic, which is a case from the International Criminal Tribunal for former Yugoslavia, and it's a decision on a motion for provisional release of September 2002. And in that case of particular significance, the trial chamber said that when assessing whether an accused should be released, the trial chamber must focus on the concrete situation of the individual applicant. And consequently, the provisions on provisional release cannot be applied in abstracto, but must be applied with regard to the factual basis of the particular case. And in that instance, the trial chamber went on to hold that a procedural measure should never be capricious or excessive, and if it's sufficient to use a more lenient measure, then that must be applied. And the court urged that weight should be attached to the presumption of innocence, the individual facts of a case, and the principle of proportionality, and that it was important to ensure the reputation of the tribunal was upheld. The trial chamber in that case held that after balancing the public interest, which included the interest of victims and witnesses who've cooperated with the prosecution, and the rights of detainees to be treated in a humane manner in accordance with the fundamental principles of respect for their inherent dignity and of the presumption of innocence, that it was convinced that the accused should be released with regard to the reality of his medical condition. And the trial chamber went on to say there can be no doubt that when the medical condition of the accused is such as to become incompatible with a state of continued detention, it's the duty of this tribunal and any court or tribunal to intervene on the basis of humanitarian law and provide the necessary remedies. And in that case, in due course, the accused was unconditionally released. In the case of Kovacevic, where again the issue of his mental condition was raised, he had conditions imposed. He was sent back to the former Yugoslavia, and most significantly, it was not accepted by the ICTY trial chamber that in fact he had deteriorated to such an extent that the proceedings would not be able to be resumed. And again, the same applied in respect of Talic. Those cases that have been cited by the prosecutor where there has been conditional release are cases where, in spite of there being sometimes terminal illnesses, that of itself has not been seen as sufficient to conclude there cannot be a trial. There is nothing that stops somebody who is terminally ill from necessarily being able to plead and stand trial. So they can be distinguished on the facts. But where in a situation that somebody is on the verge of death, the court has at times determined that for humanitarian reasons they should be unconditionally released. What we submit in this case is that the proper approach is to look at the humanitarian law considerations, to look at the reality of the situation, and to appreciate that Ieng Thirith does not at this stage need conditions. There is no legal basis to impose conditions, and her release should be unconditional, so that she is in a position to return to live with her family, where she can be cared for in the most appropriate way. Anyone who has been in this court for the last 2 days and listened to the evidence that has been given by the experts must have difficulty in considering the 6 proposed conditions of the prosecutor and understanding how they have any sense in the context of what is now fully understood about the cognitive functioning and behaviour of Ieng Thirith. We are, of course, if I can say in concluding, mindful of the concerns of the civil parties and of the victims in this case. But the overriding responsibility of this trial chamber, we submit, is to act in accordance with fair trial procedures, recognised international humanitarian law, and to prohibit the imposition of any condition which would be contrary to sense or law and is without a legal foundation. So those are our submissions. Thank you.
The President, thank you, Counsel. International Co-Prosecutor, you may now proceed.
Thank you, Mr. President. I'll be extremely brief. I was listening carefully to my learned friend's detailed submissions. We've both referred to a number of decisions. I'm unable to identify the decisions that she made reference to. I will distribute through the senior legal officer all of the decisions that I cited, and perhaps if my learned friend could do the same, so that we know which decisions she's referring to when she talks about unconditional release. Thank you.
Mr. President, we will certainly do that.
The President, we thank you very much indeed. The session now comes to an end. As the President and on behalf of the trial chamber, I am very grateful for your inputs during the course of this hearing. And again, on behalf of my fellow judges of the trial chamber, I would like to thank the co-prosecutors, co-counsels for the accused, co-counsel for the civil parties and personnel of units, sections of the administrations, security personnel, detention facility guards, TC staff members, and the interpreters for their support, without which this hearing could not have been successful. After this, the trial chamber will render a decision concerning Mrs. Ieng Thirith's fitness to stand trial in due course. I now declare the hearing closed. Security personnel are now instructed to bring Mrs. Ieng Thirith and Mr. Ieng Thirith back to the detention facility. The court is adjourned.
សូមអញ្ជើញក្រោកឈរ